Give it about a minute and a half. See if people are still jumping in here. Set up. Okay, share my screen. Yes, Singer. Got a question before we start? Okay. Hey, Russ, I saw your call coming in, but it was on this call, so get to you.
I was raring to go at 9:45, man.
All right, I got you. All right, we have okay. Oops, we're gonna hit top 70 in here in a second. Laura's in here. Maybe okay. We are recording. I've shared my screen. Hold on here. People are still jumping in. I'll keep an eye on that for you guys. All right, good morning. Thank you all for joining me on the Friday after Christmas, obviously in between our New Year's holiday as well. Many people are on vacation. Many of our staff has been out of the office as well. We're kind of a skeleton crew, if you would. I hope you all had a wonderful Merry Christmas and obviously a Happy New Year in advance. These TREC form changes, we knew they were coming. We talked about the forms changes came through last year when the lawsuit was settled, and of course now been accepted. NAR and Texas Realtors came through and changed a bunch of forms, kind of reactive to like, okay, what forms do we need to address compensation discussion because we no longer have the MLS. And then we went through all the additional forms. We had the 2402, which is the agreement between brokers to establish compensation between that's built into a listing agreement so that we would be paid between the brokers. We had the 2401 when it came to being paid for compensation from the owner directly, where it wasn't in the listing agreement. And we had this brand new form that we created, the Texas Realtors created, called the 2406, which was the addendum regarding brokers' fees. And the goal there was to meet the lawsuit or the settlement agreement saying that we're going to not only provide a way to talk about compensation in our buyer-tenant rep agreements with our buyers, require that before showing any properties on the buyer or tenant side, buyer side, and then how to disclose that in the contract so that all parties understood how compensation is being done. Okay. The TREC forms had time to review those forms. They went through the legislative process, approved new changes to the contracts that are promulgated forms, required forms to be used in Texas. So, and then they rolled out a few changes. And I guess the biggest change was around compensation. Again, it's a little confusing, which we'll cover today. But they did away with the need for the TXR 2406 now. So the form that we got used to using as a way of disclosing to the buyer and seller how the buyer was getting compensated is no longer. So the new forms replace that. Then there were some other things we're going to cover today about the form changes. So, but much more minor in scope, and then just basically more of a cleanup, if you will, of the Texas Realtors form. So, which is good. So, as a way of introduction, we're doing that as people still jumping in. Okay, and these are, if you go and look on Zip Forms, Transaction Desk, or .loop or anything else, these forms are the only forms available. So our agents have been using them, but they go, well, how do I use the new forms? You know, what do I fill in this box? And I figured it was a good time to do this since They are mandatory on January 3rd, which is obviously next week, but we're already using them, so we should probably know how to use them properly. So there we go. Okay. So what changed or what was updated during this TREC change check rollout? And they've been available now for a few weeks, up to a month, if you will. But basically, the ones that we're concerned about is the 1 to 4 family contract. Now, in TREC, whenever they update a form, they use the first number, then add to the next. So the new 1 to 4 family is the TREC number 20-18. The old one was 20-17. So another way to double check when you're looking at, you have the most recent version. And of course, at the bottom of each form will have the date. These will all be dated for the end of November, first part of this year. So long as they're the most recent forms, then you're in compliance. Obviously, the amendment to contract was updated. We'll go over that today as well. The third-party financing was updated. A crucial change there that will actually kind of clarify. I think it makes it clearer for sellers more so than buyers on this case. And then, of course, the addendum for the backup contract had the most amount of changes. We don't see that as much in our market, but it is used. And of course, you'll see why the changes were made there. And they added a new form, the addendum for the 1031 exchange, TREC form 60-0. And of course, then all of the other purchase agreements. So if any of the farm and ranch, new contract, construction, condo, unimproved, those were all updated as well. But we're going to cover the 1 to 4 today, because the rest of them have similar changes in a similar location. So for the purposes of today, we're covering the 1 to 4. So just so you know, but all the purchase contracts were changed. The amendment to contract was changed. Third-party financing addendum was changed. The addendum for the backup contract was changed, and they added a brand new form. So like I said, in the Texas Realtors changes, there was a list of like 45 forms. The fact that we only have, a few here, which is nice. And the changes here aren't as dramatic. So which good.
Hey, Marty.
Yes, sir.
Before you get started, if you don't mind, I just want to make sure we still need to get somebody to sign something to show a house.
Yes, that has not changed. That's still part of the thing. The buyer tenant rep agreement is still required, not just from the brokerage, but from a national perspective to show a property. So you have to have a compensation conversation, and done so in writing is where the forms come from. Those may be updated as well in the future, but those currently are still in place, and we prefer the long form here. But yes, that's still in place. Now, that still does not apply to rentals and to commercial, but it's still a best practice to use it for all clients, because that may have changed as well. So good question, Russ. So all the previous changes are in effect, except for the use of the TXR 2406. So they've removed that addendum, that we no longer have to use that, because it's now being taken care of in the 1 to 4. Okay.
Hey, Marty,
Yes,
on the listing side, if we get offers and the contract forms are the wrong forms, should we tell them, okay, I'm not going to look at this since you put it on the right form? Because, a lot of them will just keep using the same old forms, not realizing there's a new form. So
especially when it comes to, on the Texas Realtors forms, obviously we want to use the most recent form, and it comes back down to a broker preference. On the TREC forms, if they're using the old TREC agreements, yeah, absolutely. I'd say, we got your offer. Please submit it on the TREC forms, the most current versions, because that's what they're promulgated and required by TREC. So, yeah, I wouldn't say I wouldn't look at it, but I would say we received it. We will either have you resubmit it with the TREC forms, or we'll counter on the TREC forms, the most current ones. Okay. All right. Good question, Jeanette. So there's 6 changes that I noticed on the 1 to 4 family. Now, once again, TREC form 20-18, the old form is 20-17, and the 6 ones are pretty straightforward. The very first one is page 1. They obviously changed the number at the lower right-hand corner, and they added one word when under your natural resource leases, which we don't see a lot of, but we do see some. They added geothermal in there as well. So that was just a small change, but it was the first change of 6 and 1 to 4. So as you're reading this, obviously the natural resource leases existing oil and gas, mineral, geothermal, water, wind, and other natural resources affecting the use of the property. Okay. Change number 2 is under the survey section. You can see the red line version here. They talked about delivery of the survey. Of course, we had a couple things recently with this. So if you're box 1 there, there's 3 options on the survey. The survey says within so many days after the effective date of this contract, seller shall furnish to buyer and title company seller's existing survey of the property and the real property affidavit, T47. Then they added in here, or declaration promulgated by the Texas Department of Insurance, the T47 form. There's a brand new form called the T47-1 declaration, which is a non-notarized form. It's basically the seller saying, I declare, but it's not notarized. So the fact is, they've added the fact that a seller can provide the existing survey and a T47 that is notarized, or a T47.1 that is only a declaration to satisfy this rule. We had one recently where the survey was provided, but the T47 wasn't, or vice versa. And then the buyer wants to get out of the deal. Okay. Then they removed, if seller fails to furnish existing survey or affidavit within the time prescribed, they just removed that altogether. It says buyer shall obtain a new survey at seller's expense no later than 3 days prior to closing date if seller fails to furnish within the time prescribed the existing survey and the affidavit or declaration. If the title company or buyer lender does not accept the existing survey or the affidavit or the declaration, any one of those 3, buyer shall obtain a new survey at seller's or buyer's expense. The choice is when negotiate. So they've changed this around, allowing more options for the seller, but it also says that if the seller doesn't deliver this, instead of like giving a way out, it allows the buyer then to acquire a new one. Right down here, if the lender rejects it for any reason. I got this
So,
in the non. Yes, sir.
Sorry. Just make sure I understand. So typically that first space is 3 to 5 days after the contract.
Could be anyway, 3 to 5 up to 10 as well, depending on how much time it takes them to get the survey. Now, the first box here, though, if the seller has it, you want it short. You want it less than your option period, if you will. So you want to make sure you have the information delivered to you.
Okay.
And this is if they have an existing survey, right? Obviously, option 2, is the fact that you're going to get a new survey, and they've changed this right here: blank days after effective date of the contract, buyer may versus shall. So it makes it more passive. Obtain a new survey at buyer's expense. Buyers is deemed to receive the survey on the date of actual receipt of the date specified in the contract, or whichever is earlier. And if buyer fails to obtain the survey, buyer may terminate the contract under paragraph 2B of third-party financing because the survey was not obtained. Now, this shall and may, right? It's a different story there. And then,
Hey, Mari.
Yes, sir.
Yeah, I have a question. So meaning that it's not now it's may means that the seller is not obligated to get one, or the buyer, based on this paragraph?
Yep, that is correct. If the buyer chooses not to get one, right, they may obtain one, or they versus shall. Shall is they will. May is they have a choice. So if they choose not to, that gives them the option there too. And then, of course, it goes on to say, if buyer is deemed to receive the survey on the date of the actual receipt of the date specified in the paragraph above, says if buyer fails to obtain the survey, then buyer may terminate the contract under paragraph 2B. So it's talking about the property approval. So the buyer's best intention is to get one, but if they don't get one and they've chosen to here, this listing needs to be aware that there's still an out for that buyer.
So I do have a question about that. So
Sure.
If the lender requires a new survey, are they still obligated to or not to get the survey, or what?
Depends on which one it depends on which one you want. I mean, if you chose one where they have an existing survey and the lender rejects it, then they're going to order a new one based on what you checked here, seller's expense or buyer's expense. If the lender requires one on option 2 or option 3, then it's a lender requirement that the buyer gets it at that point in time, unless you've dictated that the seller is going to pay for it. So that's when you write it up. And if lender comes back, if they can't get the loan because they didn't order a survey, they're going to have to order a survey. But it's not a contractual obligation to the seller.
Okay, thanks.
Yeah. Now, and a lot like other thing for the seller, if an appraisal comes in and asks for repairs to be done before they can approve the loan, the seller has an option. They don't have to do the repairs, but they also know that the deal may terminate if they don't do the repairs. So it's a negotiation thing at that point in time. All right, that's change number 2, obviously dealing with survey. There's a clean copy of this. I'm gonna send it out to everybody when we're done. The red line copy of change number 3 comes under paragraph 6, and they've basically added in a paragraph 11 and moved paragraph 11 down to paragraph 12. And it's talking about mold remediation. We have a lot of properties that deal with mold. It says that there has to be a certificate of mold remediation. So if the property has been remediated from mold, seller must provide to buyer each a certificate of mold damage remediation issued under, this is a RCW, Texas code, occupations code during the 5 years preceding the sale of the property. So if it's ever been remediated, they've got to provide this basically mold remediation certificate. So make sure that this is now part of our standard contracts. And if you're talking to a seller about if they have ever been mold, they got to prep your sellers that this is going to be required by Texas state law now. And obviously on a buyer side, if they're concerned about that, you can point out in paragraph 11 that the seller's got to have to provide if there's been any mold remediation in the last 5 years, which is going to help a lot. There you go. And then, of course, paragraph 11 was moved down to paragraph 12. And this is really helpful as well, because it used to say the following notices have been given or are attached to this contract. For example, it used to say mud, PID, and so forth, right? Now they've expanded that to say utility, water, drainage, and public improvement districts so that it's much clearer to a buyer and a seller. So if you're including data which are required, if they're in a certain mud district, it would list that out. And of course, if it's in a PID or whatever, any type of district that needs to be delivered where the property is located is now spelled out so it's clearer, and you could attach them to the response, basically, when you sign the offer around. And then, of course, the seller's failure to provide applicable statutory notices may provide buyer with remedies or rights to terminate the contract. That's been added. It's new language, because we all know that during the statutory duty that the seller has a statutory duty as a state law that they must deliver a mud notice to a potential buyer prior to execution of the contract. We miss that a lot in this industry where it happens after the fact, but they have to be delivered. And with that, there is a legal recourse for a buyer in a transaction if they don't receive it prior to execution. Now, they put in the contract to clarify that if the seller fails to provide the applicable statutory notices, buyer may have remedies or rights to terminate the contract. So they're just taking the state law and putting in the contract so that everybody knows that the buyer may exercise their rights at some point in time. And it's may, because it's not guaranteed. It's not an automatic out. It's not I'm terminating because you didn't deliver these. It's the fact that the buyer has legal rights, and they may have a right to terminate the contract. So make sure the buyer and seller are aware of this new paragraph, and reiterating how important it is to deliver those notices from the proper districts at the time of contract. I saw Bara's hand up. Did you miss it? Guess not. Okay. So that's change number 3. So number 1 was just we go back here. The change geothermal being added. Number 2 was around the survey and the T47 and the brand new form for the declaration. And of course, the mold remediation on change number 3 and the language around termination possible, and the buyer having rights if we don't deliver the proper notices. Jumble those together there. Number 4, this is the one that I get a lot of calls about, and a lot of our agents are having problems with. And this is the one that does away with the TXR 2406. I have a clean copy of this. We're going to look at it in a second, but you can see the red line stuff, what was removed. So prior to the change, these new forms, it said seller shall, basically it would start off seller's expenses, and it goes on to releases of existing liens, including prepayment penalties, recording fees, release of seller's liability, tax statements or certificates, preparation of deed, 1/2 of escrow fees and other expenses payable by the seller under the contract. That's the way it was. They crossed off the expenses by seller and says seller shall pay. Once again, this is not a may, this seller shall pay. So the verbiage here is the seller will pay. This is what they're agreeing to. Then it goes into releases of existing liens, including payments, prepayment, recording fees, release of seller's loan liability, tax statements, preparation of deeds, 1/2 of escrow fees. Then it goes on to say broker fees that seller has agreed to pay. This is very important. Seller has agreed to pay, which means they already agreed. This is not seller agrees to pay. This is seller has agreed to pay, which points to the TXR 2402 or 2401, that there's an agreement in place outside of this contract where there's an agreement for compensation from the seller to the buyer broker. Okay. It says, and other expenses payable by the seller under this contract. Very important language. They probably should have highlighted this in some sort of way. And then it goes on to have 2 sections here. Paragraph B is a brand new paragraph. This replaces the TXR 2406. It says the following amount to be applied to brokerage fees that the buyer has agreed to pay. Okay, so that's very important. Listen to that. So why is we secure our compensation with a conversation with the buyer at the time of our buyer rep agreement, where the buyer is obligated to pay us a certain amount of compensation. Okay, because of that, we can show a property. Seller, and then when we get compensation from a seller or a listing broker, that offsets the amount of fees that the buyer is obligated to pay us. Okay, so the buyer tenant rep agreement comes first. Then what's coming from the seller offsets and alleviates. So this is disclosing to the seller and the buyer that the amount that the seller is paying is offsetting or eliminating the buyer's obligation to pay the broker. So they're saying, hey, there's 2 agreements out there. This is what we're doing. Very important here. So then it goes on to say that if you have X amount, or if the seller's offering 2%, 3%, 5%, whatever it may be, you could put in a dollar amount or a percentage amount, period. That is paragraph B, deals with buyer broker compensation. That you have an agreement with the seller or listing broker in writing that they've agreed to pay you already, and you're disclosing it here. And B, you have a buyer tenant rep agreement that matches that or is more than that, so you can receive it, and that's being offset by what the seller is offering. It's referring to those 2 things. Okay.
I have a question.
Yes, ma'am.
Marty, on this. So for example, I represent the buyer, and he says, I'm paying only 1% to you. All right. So I don't know how much the seller, is paying on the other side. I mean, we normally get the 3%. I mean, that's what we work for, right? Or maybe more, but 3%.
It's your business, right? Yeah.
So what you're saying here, then the seller is going to pay, but how do we know what he's paying if we don't?
Yep. This is where we go back to the former changes when we no longer have the MLS. You've got to call the listing broker and say, is the seller offering buyer broker compensation?
Right.
Is it in your listing agreement? And then you get a 2402 negotiated and in writing, so you know exactly how much the seller is going to pay you as a buyer broker.
Got it.
Then you line it up to your buyer broker agreement. Is there a difference? This is only telling you how much the seller is paying towards what the buyer owes the buyer broker. Okay. If there's additional monies above and beyond what the seller is paying, then the buyer then would be paying you the difference. Because the buyer's obligated to pay you whatever you've negotiated. And the seller's fees would offset that. And now, if a seller's fees are higher than what the buyer broker says, you have to amend your buyer broker agreement, because your buyer broker agreement limits how much you can receive as far as buyer broker compensation.
Okay.
Okay.
All
right, Elena, you're next.
Hi, good morning, Marty. Question, and let's see that I have a buyer's rep with the 3%, right? Do I add that 3% on paragraph B, the following amount to be applied to brokerage fees the buyer has agreed to pay? Then I check the second box and add 3% to that?
Only if you have an agreement with the listing broker or seller to pay that. This is on the seller paid fees. So what we're saying here is, do we have an agreement with the seller to pay buyer broker compensation? If we do, we put that amount there. And that amount applies towards what the buyer owes the buyer broker.
Okay, so what you're saying is that paragraph B has to match whatever agreement we have or with our current buyer. Is that
No,
correct?
No,
No,
you're
no,
missing
okay.
it. What, you have an agreement with your buyer
Yes,
that secures your compensation that the buyer owes you 3%. Okay.
okay.
You go to a seller and you ask them how much they're offering.
They
If the
say
seller is-
3%.
If it's 3%, then you fine, you put 3%, but you only put in there what the seller is offering, because you've already got an agreement with the seller or the listing broker to secure your buyer broker compensation. And the way you do that is like you're negotiating that with a 2402 or 2401 prior to the contract or at the same time of the contract, so that we know that's secured in writing. And then you're
Yeah.
disclosing that on the contract, because that amount will offset what the buyer owes you. But those are two different agreements. You wouldn't put in there what the buyer owes you. You put in there what the seller is paying.
Only for the seller, okay.
Oh, on paragraph B, right?
On paragraph B.
Can you just go again, because it's confusing and the wording is confusing, because I can see my seller saying, well, why should I pay them? Because in the contract it says that the buyer agrees to pay.
We're
So
in-
okay,
Elena, look, I'll read it. Here's a clean copy.
okay, better. Okay, thank you.
The following expenses must be paid at or prior to closing. Seller shall pay the following expenses: a release of existing liens, including prepayment penalties and recording fees, release of seller's loan liability, tax statements or certificates, preparation of deed, 1/2 of the escrow fee, brokerage fees that seller has agreed to pay, and other expenses payable by the seller under this contract. We're all in seller's fees. So in paragraph B, it says the following amount to be applied to the brokerage fees that the buyer has agreed to pay, applied to the amount. So you're talking about how much the seller is agreed to pay the buyer broker, that will be applied towards the amount the buyer owes the buyer broker.
Got it. That looks so much better. The other one was getting me confused with all the
I know.
colors.
I know.
Thank you.
I was
thank
showing
you.
you the changes so you can see the clean form as well. And then this is where it gets even crazier, because you've always had the next paragraph. It says, and an amount not to exceed, I put 10,000 in here, to be applied to the other buyer's expenses. So if you're negotiating a buyer concession, closing costs or whatever, paragraph C is where you put that. Paragraph B is only for the compensation being offered by the seller to a buyer broker. And the wording, like I said, Elena, is a little confusing. That's why I wanted to go over it today, is because this is that. Now, in those cases where the seller is not paying buyer broker and buyer is paying themselves, paragraph B would be 0. You would just not fill it in, or NA, because they're not offering to offset what the buyer owes, the buyer is paying. Okay, so I think Miss Customer was next. And then,
Hi.
yes. Go ahead.
Hi, it's Valerie.
Hey, Valerie.
I'm the one that had the issue with this because I got a contract already with it.
Yep.
So that, I think she just answered it. But because when my sellers read this and it said fees that the buyer has agreed to pay is 3%, that's what my seller said. Why am I paying this? Because it says the buyer has agreed to pay.
Right. Because we can provide the buyer tenant rep agreement. The buyer's obligated to, and as buyer agent, we can only receive up to the amount the buyer is obligated to pay us. And when you look at this, it does say that the buyer agreed to pay, but it says, if you read the first part, it says under the contract, the following amount to be applied to the broker's fees that buyer has agreed to pay. So the seller has agreed to pay this, and then this amount is going to be applied towards the broker's fees the buyer has agreed to pay. I know it's very weird wording.
Yeah,
Yeah,
they
the
need to
attorneys
they
did
need to
horrible.
change they need to change it to make it understandable by the common person.
Yeah.
You know?
Online, with them knowing
I
that
agree.
the buyer is obligated to pay their agent, we've negotiated the seller to bring this buyer agent and buyer to them is obligated agreement, an outside agreement, the 2402, through their listing agreement or through a separate one, 2401, to pay a buyer broker. And then those fees, or according to your buyer tenant rep, have to be offset. Basically, so those two agreements are outside agreements, but the amount of money coming in to disclose, according to the lawsuit, seller and buyer need to be aware of how these things are being paid. Buyer needs to be aware that the seller is paying brokerage, the buyer broker fees, and the buyer doesn't have to pay. And the seller needs to know the buyer is obligated to pay, and therefore it's something they need in the contract for them to offset it. And it's not going extra. It's not extra to the agent. It's fees being paid as per agreement. Okay, I know it's confusing.
Marty, just real
Yeah,
quick.
it makes absolutely zero sense, but it is what it is.
Yeah, well, it's the wording, right? Because it's shall and may and that kind of stuff will pay. But
I mean, it
this
could
is-
have been much easier. Just seller has agreed to pay X amount to buyer's agent,
Mhm.
something like that.
It could have been easier, right? But we were dealing with attorneys and brokers, right? Writing the forms. And apparently there's lots of discussion around the language. It may be edited again, probably will be, but for now, no. And yeah, for the seller, but for seller, bottom line is you've had your discussion with the seller at your listing appointment.
Yes.
We're offering up, a total compensation. Here's what I'm charging to list and sell your property. Part of that cost is to draw in buyer brokers to have buyers. Now we're going to offer up a certain amount of compensation. You've allowed me to disclose the amount we're offering. That has to be secured in writing prior to the contract or at a contract time, so that it is secure. Then you're signing under that agreement saying here, no matter what, with this buyer buying the property between this broker, we've agreed to pay that broker X amount. Okay. And then that's carried forward when we're reading the contract. Here's that amount we've agreed to pay the buyer broker. That takes the burden off the buyer, in this case, so they can buy your home. This is all part of our cost to sell. So it's one of those things where you're prepping the seller from the very beginning. And then when they see the contract, you're explaining and bringing them back to the listing agreement of why you did the things you were. You're not paying them on behalf. This is a part of the thing where the buyer doesn't have the resources to do both the down payment, buy the house and so forth, and pay the buyer broker fees. So this is part of the agreement. Okay. All right, Andres, you're next.
Yes, so I had two questions about the compensation and everything like that. So the first question is, okay, to know that I understood correctly, if I have it signed with the buyer that I'm gonna get 3%, but they're only paying 2%, the buyer is responsible for the next 1%, correct?
That is correct.
So now if I have a buyer that wants to pay, we negotiate, I'm putting it out there. Somebody negotiates with someone for 1.5 or 2%, but the seller is paying 3%. Do I have to give that 1% to the buyer and such, correct?
No, if the seller is willing to pay 3 and you have 1.5 on the buyer tenant rep agreement, you could only get 1.5. So the seller's not going to pay more than that. You've got to amend your buyer tenant rep agreement, have your buyer sign it to match what the seller is paying.
Okay, now if you have a buyer with a 3%, but you get into a new construction that they're paying 3% plus a bonus or whatnot, are you able to receive that bonus?
No, you have to amend it, your buyer tenant rep again with the 1505 to disclose to your buyer that the seller, the builder, is offering a buyer tenant bonus and buyer brokers.
So would I have to do an amendment on there or something?
Yes, that's what I just said. You have to amend your buyer tenant rep agreement with a TXR 1505.
Okay.
To show the buyer that you're getting more money from the builder.
Gotcha. Thank you.
And if they don't sign it, you can't get it.
What?
Yeah. You
Right.
can't get it. You cannot get any more than the buyer has agreed for you to get. Okay. So make sure this is very clear, because this dictates. So that's why you don't sign a buyer tenant rep agreement for 1% or for 0, because that limits how much you can actually make in a transaction. You negotiate your value. This is what I make. If I get more from the seller that offsets your liability, I will come back to you to amend this to represent the more. right? Because that buyer is going to look at you and say, hey, if you're getting more, then I want more, right? Right? They're going to say, why do you get more and not, why don't I get a concession? Okay, so make sure you're prepared for that.
Makes
Marty.
sense. Thank you.
Well,
Next up is Hingama. And then Jeanette.
Then the buyer tenant agreement needs to be with, I mean, I never used to send that with the sales contract. In this case, it has to be given to the listing agent. Like if I'm representing the buyer, then that buyer tenant agreement has to be submitted there and with the offer. With
Not,
the sales
not
contract.
necessarily. Just like the listing
Okay.
agreement is the agreement between the seller and the listing agent that we don't get a copy of it. The
Okay.
buyer tenant agreement is between you and the buyer. Unless the buyer has to pay some, then you have to provide it to escrow. Now, the listing agent has a right to ask you for it to see if you have one because it's required. Then if you don't supply it when they ask for it to verify whatever it may be, they can tell HAR for it to make sure you have it. And if you don't supply it to HAR, then they can fine you. So there is a policing aspect to this, Jeanette. But the biggest thing here is the seller offering compensation? If they are, get it done in writing. If you need to provide your buyer tenant rep agreement to get it in writing, do so. Otherwise, you wouldn't have to.
And if there's a revision that we need to make to that, then that needs to be made prior to, let's say in the negotiations, we have to give up something. Okay.
Right.
So the buyer tenant agreement has to be revised also in order to match everything.
yes.
What's funny about that is they say you can't take more, but you can always take less. It's always best practice to amend it regardless to match. But you can, let's say that they're offering 3 or 2 and your buyer is obligated to pay you 3, but you'll take 2. You don't technically have to amend it down to 2. It's always best practice.
The way that they have it worded here, those
Yeah.
sellers are going to say, well, I gave them a discount on the price. I don't want to pay that 3%. And then I realized the 3% is coming out of our pocket, not the buyer's pocket.
Once again, this
So-
is where you have to have a good listing agent showing that this 3% was already baked in a separate agreement through the listing agreement and through the agreement between the brokers on the 2402. Now, all we're doing here, this is not a new term like 2406 had a new term. This is a disclosure of up here of what the seller has already agreed to pay.
What a can of worms, Mark.
I get it. We don't have all day long, but
I know.
Okay.
Russell, you're up, buddy.
I
think-
I didn't ask my question.
Oh, I did. Yes, I did.
It's Hengame, yeah. I just want to know about if you have the buyer agreement for like 3%, and then sellers will offer 3%. Okay, but or no, offer 2%, and then the difference, if you don't want to get it from the buyer, even if you have on your agreement, can you just credit it back to them or let them have it, or how it works? Like if you get 2%
Mhm.
from the seller, and then your buyer wrap agreement is 3,
Mhm.
but then as your client, longtime client, you don't want to get that 1% from them, are you able to do that?
Yes, you don't have to credit it back to him. You can say, I'm not going to collect that. CDL did 2%, just what the seller's offering. As Jeanette and I were talking, you can amend it to represent so they can see that you're lowering your compensation on the buyer tenant rep to match what the seller is making at 2%. Probably best practice. If you want to do that, you don't have to, but you want to put them at ease. But you can always take less. You just can't take more. So to your point, yeah. Now, on the agents that don't want to do that, and we've had those as well, you have to provide your buyer tenant rep to the title company so they see that there's a difference between what's being paid in the contract and what's actually owed to you outside the contract as well in those exterior agreements. So make sure that if you do want the extra 1% from your buyer and they're willing to pay it, make sure the title has a copy of your buyer tenant rep. Okay.
Okay.
I know there's lots more.
It's okay.
Wendy, how about you? But real quickly.
I asked a question a little bit earlier. Let's see. So if we're not we leave it blank,
Mhm.
if the buyer is not paying anything
Uh-huh.
and you're taking 2%, or you're dealing with builders at 1% or whatever, if you're doing that way, you just leave it blank.
If the buyer is paying you whatever it may be and the seller is not paying you anything, yes, you would leave it blank.
Okay. But if the seller's paying you,
Then you have to put in what the seller is paying you right there.
okay.
And whatever you have in writing. On builders, it's oftentimes different. They won't have a 2402 or a 2401, but there'll be something in the contract that talks about what the builder's paying buyer broker. That's what you
Okay.
need. And it has to represent that in the contract here, what they're paying you. Yep.
Okay.
And you should have a buyer tenant rep agreement in place.
Yes.
Match.
Yes.
Yeah. Okay. Good. Admin, I don't know who that is. Go ahead. Okay. There you go. Then obviously the compensation one's big. They just added on the Miguel, hold on a second. And then paragraph 2 goes into buyer shall pay. So before they had seller shall pay, seller fees, buyer fees. They reworded these things, and they added basically the brokerage fees that buyer has agreed to pay at the bottom. So you have up top the seller agrees to pay, that applies towards, and then it talks about buyer agrees to pay, including the brokerage fees that buyers agree. That goes back to the buyer tenant rep. So the top here is referring back to that agreement between the listing broker and the buying broker, or the seller and the buying broker that they've agreed to pay. And then down here in paragraph 2, it's referring to the buyer tenant rep. So title knows, buyer and seller know that there's 2 outside agreements. There's an agreement between the buyer broker and the buyer. And there's an agreement between the brokers about compensation, or between the seller and the buyer broker about compensation. So it's referring to those things and bringing them into the contract as a form of disclosure. Miguel.
Yes, I have a question. Is it allowed on the rep agreement, buyer rep agreement, to add on the special provisions that the buyer is willing to pay any BTSA? I don't know if I worded this correctly, but let's say that we got into a contract with a builder and they pay a bonus, right?
Right.
BTSA. Can we say that in advance, even not knowing what the amount will be? Let's say,
No.
is it clear, my question, or not?
No, you basically, you're saying an undisclosed amount up to, no, you've got to amend it to show what the amount is. So if you know what the amount is, you can say, the 1505 is the only place you can actually put in buyer, the BTSAs. So up front, you could have a buyer tenant rep agreement and an amendment to that to reflect the expected amount you're getting from the builder as a bonus. Now, then, of course, if that bonus is different than the expected amount, then you have to amend it again to have the exact amount if it's higher.
My question is because D.R. Horton asked us to send the buyer representation agreement, and when they have bonuses, they are not paying the bonuses. So the question will be, is it allowed to put up front in the special provisions that if we get into a contract where the builder or seller is paying a bonus, the buyer agrees to pay that bonus to us, and after that do an amendment for the right amount?
No. One, you're practicing law, so no.
All right, thank you, thank you.
Okay.
Hey, Martin.
Yes, ma'am.
This is Abida. I'm sorry, I'm signed in with my son's Google thing. That's why it's showing you as admin. I have a quick question on 12C. The amount not to exceed, does that include the compensation as well, or that's only what the seller is contributing towards the closing?
That's only what the seller is contributing to the buyer toward closing. They put them in the same place, which is weird, but B is your buyer broker compensation and C is your concession to the buyer. Now, the C still has that same requirements. It's all about, allowable closing costs, concessions, those type of things for the buyer's loan.
So for that C, is there another form for the B compensation is the 2401 or 2, right?
Correct.
And for the C, is there a separate form now?
There's not. They haven't created a separate form for that. Although you could go back to and review that it's tied to the third party financing in some cases, because you're asking for closing costs, but it's not, it's loosely. So no, there's no other form for that. Good question.
Okay. Okay, thank you.
Yep. And this is the one too, just on a side note, and it's outside of conversation. And then the laws may change, but certain loan guidelines haven't, because we don't want lenders treating the buyer broker compensation as concessions to the buyer, which in some cases they might. We have to watch out for that. But there are limits. Sometimes like an FHA loan or something like that will allow up to 3% concession from the seller to the buyer. VAs may allow up to 6%, right? Be watching this, because the amount you put in paragraph C is applied towards the amount of money the buyer can use, lender can use, right? So they're buying down the rate, they're paying for closing costs. But if there's more money, let's say it's 10,000 and they can only use 5,000, that extra 5,000 doesn't go back to the buyer, it goes back to the seller. So make sure that we're aware of that you talk to your lender and saying, how much do we need for closing costs and expenses, and how much can you use? And we're not going to ask for any more than that. You can do it in a price reduction instead. So, okay, I think Sarah, you're next, and then Wendy. Sarah, you there? Okay,
Hello.
Wendy, you're up. Oh, Sarah, okay, go ahead.
Okay. Hi, good morning. So I have a question here where it says the 10,000. What if the builder is offering more?
That's fine. I just put numbers in there for reference. That's all.
Oh, okay. So I thought okay, perfect. So whatever they're giving is what you have to put there, right?
That's correct.
It can be like 10 or 15,000.
It could be 100,000 if you want, whatever. It's just, I'm just saying, don't put too much that the lender can't use.
Where,
That's all.
where is that, Marty?
Thanks.
Paragraph C.
Where's the 100,000 you said?
No, I'm saying you can put, yeah, right. that's funny. Yeah. All right, Wendy, you're up, and then we'll keep on going.
Hey, I'm sorry to not be clear about this, but explain to me one more time. Buyer shall pay, on C.
Mhm.
And then thou shall not exceed. This is for if you're doing a rebate back, or
This is one of those things. Oftentimes, a buyer that's doing FHA, USDA, or VA doesn't have the resources to pay their closing costs. And oftentimes, they'll make an offer subject to a seller giving them a concession or a payment towards
concession.
Yep.
Okay.
Yep. That's what it is. So paragraph C is the seller's concession to the buyer.
Okay, gotcha.
And it's limited not to exceed, because there's, they can use less than that, if you will. So
Is it 6? Is it 6% is the number that they can have
6%
concession?
on VA loans? On
Yes.
conventional and FHA, oftentimes as low as 3. So you have to check with your lender.
Okay.
Okay.
I got lost on that.
You got lost on that?
Yeah, I did. I didn't know you could hear me.
Yeah. Sorry, guys. Go ahead and mute yourself, everybody, please, so that we don't interrupt the recording here. But just on that, it's not part of the form changes today, but generally on lending guidelines, if you're getting a loan, there are restrictions on how much a seller can credit a buyer towards their closing costs. On FHA and conventional, oftentimes is as low as 3%, depending on the loan product. On VA, it can go all the way up to 6% of the purchase price for a credit. And just be aware of the loan guidelines. What kind of loans your buyer getting? Which lender are they working with? Make sure you understand from the lender how much the buyer can actually receive if you're negotiating concession. That's the biggest thing there. Okay, moving on.
Marty, I have a question. I'm sorry.
Okay, what's up?
Good morning. So if as a buyer's agent, I'm going to give a certain percentage of my commission to the buyer to help them with closing costs or fees, where does that have to be disclosed at?
Nowhere. You can do what you want to do with your compensation to your buyer. We have a form called commission waiver letter. We can do that if the title company or builder needs that. And I sign that off. Otherwise, you should do it in your CDA. When you do an OTPC or CDA, you say, I'm entitled X amount of dollars. Out of that, I'm going to credit so much to the buyer. It goes on a line item in the closing statement saying credit from buyer's agent to buyer. That's fine.
Okay.
Nowhere in the contract.
Do I have to notify the lender?
Yes. Yes.
Okay.
Because once again, that goes into the cap of how much the buyer can be credited from all sources. Right now, we're talking about in the contract here, we're talking about the seller credit to the buyer. but the
Yes.
lender needs to know how much credit the buyer is actually getting from all sources. Yep.
Okay, thank you.
You're welcome. Good question, though. That's a good question. All right. I just put this in here for a second. This is the 2402 because it's still that necessary form to make sure that you get your compensation secured, being paid for by the seller to you or from the listing agent to you in there. And the reason we say the two places is because listing agents may be listing a property and they may include a compensation to a buyer broker, which is probably what most of them will do. Some of them have listed properties where they're only including compensation for themselves and zero to a buyer broker. If you find that out, you would use the 2401 instead and say, seller, I have a buyer. I want to submit an offer on your property, but I need you to pay my compensation.
You can take the car to go get lost if you want.
All right, mute. Let's see here. Let me check this out real quick, guys. One here. Not seeing it. Okay, okay. Watching it. So this is here. This is referred to in the language, and I agree with all of you. The language is terrible, but the more we can go through it, the more we can explain that the language around that is the seller shall pay what the seller has already agreed to pay. It's going to be a lot better when you start reading these things. Then, of course, the next change, of course, the last change was the adding the 1031 exchange document. If you deal with that, obviously we use third parties for that, but there's an addendum that they created, which we're not going to cover today. That's another checkbox on the 1 to 4 family and all the purchase agreements. Okay, that's a lot. I'm going to go over to the third party financing. The changes were made there, and this is now TREC form 40-11. The old form was 40-10. So again, the newest versions always add on an additional number, so you know which form you're using. The biggest thing, this is really, really helpful. I just want to now, here's the red line version, and I don't want you to get confused. The paragraph B has very minor changes. Okay, the paragraph B has always said if buyer's lender determines if the property does not satisfy lender's underwriting requirements for the loan, including but not limited to appraisal, insurability, lender required repairs, buyer, and it goes on to buyer may terminate this contract. It says on no later than 3 days before the closing date. And it was confusing the way it's written right here, but they removed some of those things, so it's much clearer about the 3 days. So the way it reads now is buyer but not limited to appraisal, insurability, and lender required repairs. Buyer may terminate this contract on or before the 3rd day before the closing date. So at any point in time prior to the 3rd day prior to closing date, even if it's 10 days into the contract or 20 days in contract, if the lender rejects the property, you can't get insured, the appraisal won't come in at value, whatever it may be under these terms here, the buyer can terminate the contract because of the property approval. Before it was up to 3 days, it wasn't specific, so in here it was much clearer. And then it goes on to say, by giving seller notice of termination, which is the form, buyer's notice of termination, and a copy of the written statement from the lender setting forth the reasons for the lender's determination, low appraisal, non-insurability, and so on and so on. And it says, if buyer terminates on this lender setting, a paragraph, the earnest money will be refunded to the buyer. If buyer does not terminate under this paragraph, property approval is deemed to be obtained. So minor changes, except clarifying that you can do it at any point in time of the property disapproval up to the 3rd day before closing. The buyer may terminate based on the lender's denial. If the lender provides a letter, you provide a termination notice, and you do so in time. Paragraph A didn't have that specifics. What they did said, all right, buyer may terminate this contract. So before you say give written notice to the seller within blank days after the effective date. So now it says the buyer may terminate the contract within so many days after the effective date by giving the seller notice of termination. Once again, the buyer's notice of termination form that they didn't get approved, and a copy of a written statement from the lender setting forth the reasons for the lender's determination. That was not required before. This is new contract language saying that the lender can't just say you denied. Buyer can't say I terminate because I didn't get approval, because the buyer may not have gotten approval or did all the process they're supposed to. You need a written letter from the lender now saying the buyer was denied for credit purposes, for their debt to income ratio, or whatever it may be. So there's more obligation on the buyer, and this is helpful for the seller, saying, hey, they've got to be denied, and we got to have something in writing along with the termination from the lender stating why they were denied in order for them to use this paragraph for them to terminate. So the buyer's agents, it's not a get out of jail free card for no reason. You need something from a lender stating the reason the buyer was denied, that the buyer actually made application, actually got through the process and was denied, versus saying, they were denied and way out. It's no longer sort of like a additional option period. It is that. So this was a good change in my opinion. Okay. We still have questions here. Are we on to this yet? Let's just go back to Miss Customer, which is Valerie. If not, we'll go to admin, which is, and then after that, we'll go to manual. Emmanuel?
Can you hear me?
Yes, I can hear you now. Yep.
Yeah. Manual Thad, it's me, simple.
I know. That, yep.
Well, just want to alert and ask you a question as a follow-up. Section 2A and B, because I've had this happen to me in the past, because sometimes when we read that, we forget that both section A and B applies in this document. So just because you check in one box in section A does not take away section B.
Yes.
Right. Because
yes.
Because I've had a situation whereby unfortunately I had an agent come back and say, well, I said, well, if you look at the language of the third party financing addendum, A has 2 boxes. Obviously, you have to check one of those boxes, but B applies to the whole document itself. So A and B are part of the third party financing addendum. So just want to bring that up.
Yep, it's very good, because oftentimes people don't understand the buyer approval, whether you make it subject to them or not, or it's box A1 or box A2, is a condition. Is the buyer credit worthy? Will they be given a loan from the lender based on their credit worthiness, their income, their debt to income ratio, their credit report, whatever. B, as Stab was saying, implies to, if you're including this addendum, regardless of whether the agreement is subject to the buyer's approval or not, the property is subject to it. If you're getting a loan, the property has to be approved as well, meaning does it appraise for the value? Is it insurable? Does it need flood insurance and so forth? Are those things? Can the lender lend money on this property? And if the lender can't lend money on this property, not the buyer, they can have great credit, great scores, whatever, they can still be terminated. So there's 2 approvals. There's the buyer approval and the property approval. And to that's point, if you include the third party financing, the property approval is included for all properties. And then the buyer approval is a separate thing. Oftentimes agents will, hey, you've had 21 days, buyer approval's gone. Yeah, property approval exists all the way up until the 3rd day prior to closing, meaning that if the property gets denied by the lender and the lender provides a letter stating why the property was denied, and the buyer and buyer's agent send a termination notice within the proper timing, 3 days prior to closing or earlier, then they can terminate and keep their earnest money. So yes, good question. Good add there. Okay. But so the language here, so they've modified some of the language so it's clearer on the 3rd day prior to closing, and they added new requirements for the buyer to provide a lender letter when they terminate based on buyer approval. Okay. So here is the clean version of that messy stuff. So you can see it in the way it is. So buyer approval, once again, they added paragraph 2, copy of a written statement from lender setting forth the reasons. And then of course, down below, it says the same thing. The addendum for the backup contract. This is the most amount of changes. And obviously I want to go through this This is one when there is an existing offer on a property. It is pending closing between a buyer and a seller. And you have a buyer that wants to make an offer on the property in the backup position. Meaning your offer is fully executed, an agreement between your buyer and the seller, but it's subject to the first offer that's already executed falling through. Okay, so that has been changed. Now the new one's 11.8, which used to be 11.7. And of course, that's really, really small for you guys. So I'm going to send this out afterwards as well. But all of that blue language is new verbiage that was added to this new contract. And I'll read it so I can read it from my side of things, but they crossed off basically provides in backup contract. So it says the contract to which this addendum is attached, the backup contract is binding upon the execution by the parties, and the earnest money and any option fee must be paid as follows. Then it goes on to the new language. It says buyer shall deliver earnest money and option fee as provided in paragraph 5 of the backup contract. And paragraph 5, of course, is the earnest money provision in the 1 to 4 family. Number 2, buyer shall deliver additional earnest money and additional option fee to the escrow agent within so many days after the amended effective date of the backup contract defined below. So we start off here. First of all, it says that you must deliver option money and earnest money as per the contract, as if it's executed and the clock started on the day you got an agreement. Okay, it's saying that yes, you have to deliver option money and earnest money to escrow. Then paragraph 2 gives the option for delivering an additional amount of earnest money, an additional amount of option money upon this second offer going into first position, upon effective notice and the revised date. That's still negotiable, but sometimes you might want to put up a small amount of earnest money and a small option fee initially, not knowing if this buyer will ever be in first position. Okay, and then you would increase that earnest money, option money, when the buyer is actually in first position. Okay. Then additional language is if the last day to deliver the additional earnest money or the additional option fee falls on a Saturday or Sunday or legal holiday, the time to deliver the additional earnest money or additional option fee as applicable is extended to the next day that is not a Saturday, Sunday, or legal holiday. Typical language. The amounts escrow agent received under paragraph A2 of this addendum shall be applied first to the additional option fee and then to the additional earnest money. And then buyer authorizes escrow agent to release an additional option fee to the seller at any time without further notice in or in context, and releases escrow agent from liability for delivery of additional option funding to the seller. Additional option fees will be credited to the sales price at closing. So paragraph D deals with at the time when you go into first position that you deliver additional option fee. That option fee is delivered to the seller by the escrow agent, basically becomes non-refundable at that point in time. And then the buyer and seller are holding the escrow agent basically harmless or releasing that funds. And then if the buyer does close on the property, it's applied towards the buyer's cost. If the buyer doesn't close, obviously it's lost money. Okay. Then it goes on to say failure to timely deliver additional earnest money. If buyer fails to deliver the additional earnest money in the time frame required, seller may terminate this contract or exercise seller's remedies under paragraph 15, which is the default paragraph, by providing notice to the buyer before the buyer delivers the additional earnest money. So again, in the original contract, you have 3 days to deliver earnest money and option money. If the buyer doesn't deliver it in those 3 days, the seller has the right to terminate normally. Now you have an executed contract, you've delivered option money, you've delivered earnest money, and you're in second position, you're in the backup position. Seller now gives you notice that you're in first position and you've agreed to put additional earnest money, option money into. The clock starts again, and then the buyer the second buyer doesn't deliver in time. The seller again has a new right to terminate this contract with the buyer for non-delivery of the earnest money. So make sure that the buyer understands that when we get notice and we are in first position and we've agreed, you must deliver it within the time frame allowed. And of course, failure to deliver the additional option money fee If buyer fails to deliver any required additional option fee within the time required, buyer shall not have the unrestricted right to terminate the contract. So you built in a contract early on with the option period of 10 days or whatever it may be. That's a effective date gets changed. And then here you've agreed to deposit additional option money and you don't do it, or you don't do it in time. The buyer then waives their right to have an option period to terminate with the unrestricted right. So make sure they understand that as well. Then the rest of the language is the existing language. It would just move down in new paragraphs. It says a backup contract is contingent upon the termination of the previous contract, the first contract dated blank, which is the contract between the first buyer and the seller, except as provided by this addendum. Neither party is required to perform under the backup contract while it's contingent upon the termination of the first contract. The next line, if the first contract does not terminate on or before the timeline, the backup contract terminates and the earnest money will be refunded to the buyer. Seller must notify buyer immediately of the termination of the first contract for purposes of performance. The effective date of the backup contract changes to the date the buyer received notice of termination. So basically, when the first contract has terminated, the listing broker notifies the buying broker that they're now in first position. That would be the brand new effective date of this backup buyer now is in contract with the seller. And the effective date, which was like, let's say 30 days ago, is now today, as we've got it now in first position. And then it goes on to say an amendment or modification of first contract, but will not terminate the first contract. And then, of course, if the buyer has an unrestricted right to terminate the backup contract, the time for giving the notice of termination begins on the effective date of the backup contract and continues after the amended date upon the expiration. So let's say you've negotiated a deal with the buyer and the seller and you're in backup position. You have a 10-day option period. That 10-day option period starts when your effective date and continues to go. The clock doesn't start counting, but all the time up until the point where the second buyer becomes the first buyer, they have the right to terminate. And then once they're in first position and the effective date has changed, then they have their 10 days in the contract period to exercise their right to terminate under the option period. So be very clear. It's the only thing the buyer has to do in a backup position is deliver option money and earnest money to escrow within time. Everything else is on hold, if you will, until they're made in first position. It's a lot of language added, but most of it's legalese showing that around delivery of option money and earnest money. Okay, I know there's questions there. This is the cleaned up version, so you can see what it looks like in the actual document. Lots of new language. So, Jeanette, your question?
Yeah. So the risk to the buyer, if they want to put up a backup offer, is that option fee. The first option fee that they put, they don't even do the inspection until they become the first contract, correct?
No.
So the only risk is the option fee. Is that correct?
That's correct. That they would put in the earnest money and option fee, whatever they put in the contract with the seller, they would deliver that to escrow. The only risk to them is the option fee at that point in time. Now, because they'll get the earnest money back if they terminate prior to coming in first position.
Correct. Now, let's say, for instance, in the meantime, they find something else and they want to pull out of the backup offer.
Yes.
So then you just do a termination, correct?
Do a termination because you're actually in your option period. So you use your termination notice based on your unrestricted right to terminate, and you terminate, you receive your earnest money back, but the option money is gone. Correct. Yep.
Okay. And not having done inspections or anything.
That's correct.
That's just money gone out of their pocket, and we should explain it to them that way.
And that's why you probably would look at like maybe $100 for option fee, and then in your backup offer addendum, you might want to put additional option money.
Yeah. Okay. Good idea. Good idea. Thank you.
You're welcome. Valerie, you're up.
I think I got my
Question answer.
thing working now.
Okay, good. No, you're fine. All right.
It actually goes back to a question before.
Sure.
So if my buyer or if my listing agreement stated that I was doing 5%, 2.5% to myself and then to the buyer's agent, 2.5. But then we negotiated 3% to the buyer's agent. Do I need to do an amendment to change the listing agreement?
Yes.
Okay.
Because the seller's only obligated, you know, they're going to obligate themselves, but the purchase agreement between buyer and seller discloses the agreement that's already done. So if the seller has agreed to pay the buyer broker an additional amount, 3%, right? In a 2401, then you wouldn't. But if you're signing a 2402 agreeing to pay the buyer broker 3%, and you've only got 2.5% in your listing agreement, you need to amend it. Otherwise, it's coming out of your share.
Okay. I'll do that today.
Okay. Yep. Perfect. Okay.
Thank you.
And the last one, the next form that was changed was the amendment to the contract. As you guys all know, we use this for our inspection response. We use this for just about everything. It was 9 paragraphs long. It's now 10 paragraphs long. And the reason, because they added that line in paragraph 12 of the 1 to 4 dealing with buyer broker compensation. So they added that in paragraph 4 now and moved everything else down. So basically paragraph 4 in the amendment says the amount in paragraph 12A1B of the contract is changed. 12A1B is that amount towards the buyer's concession. Okay. And then of course they should have put these in the reverse order. And then paragraph 5 says the amount in paragraph 12A1. Oh, sorry. I was right. 12A1B is the buyer broker compensation. So it says the amount in that paragraph is changed. And then paragraph 5 is now 12A1C, which is the concessions to the buyer. And then everything else is moved down. So they've added that language from the 1 to 4 so that it could be amended in the amendment. So now you have 10 spaces versus 9 dealing with the addition of buyer broker compensation in the contract. It's a pretty simple change, but make sure we're using the most recent amendment form, which is this one right here, which we just looked at, which is 39-10. The old one was 39-9. Okay, here's the clean version of that. Okay, so you can see it's in 10 pages. And of course, the sample 1 to 4, we are really running out of time. Let's see, let me check this out. I just want to show you this real quick. Like, stop this one. This one. We're going to see a lot of this. And of course, there it goes. So this is your 1 to 4, the most recent version. You can see on the top, it was created 11-4. Down at the very bottom here, I'm going to go down to the bottom. Don't get dizzy on me. 20-18, so we know we're using the most current 1 to 4 contract. And like I said, the verbiage changed, but going back to 12, we can see right here, this is where a lot of us get stuck up on today's call and of course in general. Just have a conversation. Be very clear here. The seller shall pay the following expenses. And it goes down here, brokerage fees that seller has agreed to pay. That's that outside agreement. So then of course you would disclose that in paragraph B, sessions to the buyer, paragraph C, and then talk about that there's buyer's expenses too. So 1 is about seller's expenses, 2 is about buyer's expenses and what they've agreed to pay. And that includes the buyer brokerage fees that the buyer has agreed to pay, which is the buyer tenant rep agreement. So stop this. So could TREC do a better job? Yes. Is this what we're stuck with for now? Yes. Our job is to educate our buyers and sellers that, hey, this is new forms. This is the ones we have to use. These are referring to agreements that you don't see. The listing agent is offering compensation that will offset the language in your buyer tenant rep agreement. We're disclosing that in the contract, and then that's why we have to amend this or to match that or whatever. And then of course you have a discussion around if there's anything different between what the seller is offering and what the buyer has to pay. All right, I have more questions. Let's see here. All right, let's see. I'm going to go to Sharon, and then we'll come back to you guys. Sharon, you got a question?
Yes, excuse me. I've had amendments made to 2 condos that the agent on, and we've now on our 10th amendment. We're
That's
talking,
fun. Yeah.
Yeah, we're talking about almost 4 years, and our last amendment was supposed to have been signed on the 17th, I believe it was, of December, and he has not signed it. So what is our option now after all this time?
So you have an amendment that extends closing and they won't sign it.
Right.
Okay. And who won't sign it, the buyer or seller? It doesn't matter really. But
The seller, the builder.
Okay, the builder won't sign it.
Right.
And so, and the buyer is ready to close, but the builder is not, correct?
Right.
Okay. Yeah, the contract language says that, they've agreed on a certain closing date. If the buyer is able to perform, then the seller is in default, and then the buyer has remedies in any case, whether it's 3 years or 4 years, whenever they don't sign, if prior to you getting out of contract, the buyer should talk to an attorney saying, hey, I have either I keep my earnest money, walk away. I can sue the seller for performance to make sure they close on time or whatever, or I can sue for damages because that's in my right in the contract under termination. Now, because the seller is in default, paragraph 15. If the buyer can perform, the same thing, the seller has a right to terminate at that point in time. But you have a closing date that is coming up and the seller can't perform, they're in default. But the buyer has to seek legal remedy at that point in time.
Right. So my next move is to seek an attorney.
Correct. Yep.
Okay, because I've got 2 contracts there. So
Yep.
it's a double whammy.
It is, and dealing with builders is tough because obviously they have attorneys as well. But you've got to, and sometimes obviously you can amend a contract even after it's dead. But if you don't go after an attorney here, the only remedy for the buyer is to force it through legal action.
Right. Okay. So can the buyer of the other condo come after me in any way as their agent?
Not for what reason. They can always come after us, but the point is no. I mean, not for the fact that they can't get the seller to sign, no. Or if the seller refuses to sign an addendum, that's on the seller.
Right. I think they contacted an attorney and they said, well, we can go after your realtor also.
Yeah, and then they have to give reasons. Like once again, there's very litigious out there, but no, if you're representing your client, you've presented the addendum, they won't sign it. What are they going to go after you for? You've got an agreement to advocate for them. You did. So,
right.
Yeah.
Okay. So the insurance that we have through your company, agent's insurance, what does that cover?
Errors and omissions. Yep. If you made a mistake, then basically you have a deductible that it covers attorneys to defend you where you made a mistake. But if you haven't made a mistake,
no.
Yeah.
Not me.
Yeah, right. Okay. I know we're going along, but Kevin, you have a question? Give me a second.
Yes, good morning. And thank you so much for this. Just to summarize, the form that has been changed is a third party 124 backup offer, and the other one was TREC 39-9. I just want to go print them and go over those forms. Just want to.
Yep. I'm going to give you the list again here.
Thank you. Thank you.
Let's see here. Share.
Yeah, the list. And this goes to effect on January 3rd, correct?
It's mandatory on January 3rd. They're all available now. So basically all your purchase agreements from your 1 to 4 through the amendment to the contract, third-party financing, the addendum for the backup contract, and of course, the brand new form, the addendum for the 1031 exchange. So those are the ones that could change. So, all right. So while we're doing that, I think we had Hengama.
Yes, I have a question about it is I think nothing to do with this, but if somebody wants to buy a house cash and also there is tenant in that house, how that goes? I mean, what kind of, I mean, I know you do the contract, and then do you have to add anything to it in case the tenant does not leave after the contract is over? Or
Yeah, that's the there's an assumption of leases addendum. Basically regarding leases, you have to add if the tenant's going to stay past closing, the landlord, the buyer now becomes the landlord. So the lease continues unless the existing owner and tenant agree to terminate their lease prior to closing. That's in your negotiation. But if it's not, if you're buying a property cash, a tenant's involved, there's a lease involved, you need to add the addendum. I believe it's here.
But if they are not leaving until after they closing, but automatically the new owner would take over?
Yep.
Yeah.
The new owner will
I
assume
don't,
leases.
do I have to still do the addendum for the lease or no?
Yes, because they're assuming the leases. You want to make sure that the new buyer gets the leases transferred into their name as the owner of the property, and it's important. So yeah,
Okay. And another, I'm sorry, it has nothing to do, but another question was like, even if it's a cash offer and they close in 10 days, do I still have to put option money in there for like 5 days or 6 days or no?
option money is not required. Yeah, that's only if you want the unrestricted right to terminate during a period of time. So if the buyer wants to waive that, they don't have to put option money.
Oh, okay. Thank you so much.
You're welcome. Okay, Jeanette. She's just looking for the mute button. That's not it. There you go. All right. While I'm waiting for Jeanette to jump up, Andres.
Yes. So if all these are effective on the 3rd of January, if you have a closing on the 6th, do you need to change any of the contract or just go as is?
No. Any pending sales these are only new transactions written after the 3rd of January. So no changes needed. So you're good. Good question though.
Marty, I don't have any, I forgot what the question was. It was so long ago when I thought about it.
You are good. Let's see.
Good, thank you.
All right. So I got you down. All right. Got hanging me down. Dad, you got something else for me?
Yes, sir. Just real quick. I'll make it real quick. So going back, to the 1 and 4, right? So let's take the example of a 12-1C. I'm trying to remember it off my head. Let's use that $10,000 as the amount.
You have an issue with it?
No, just painting a scenario. So that comes before the amendment. So let's say the buyer did an inspection. The inspection, approximately all the items on the inspection probably cost about $4,000. So what we need to be paying attention to is that even though the 1 to 4 came first, promised $10,000. Now, after the fact, we now have an amendment based on inspection. Now the question between myself and the buyer, and this is just a scenario I'm paying the discussion between me and my buyers. Okay, buyers say, oh, well, let's negotiate with the seller. Give me $4,000 at closing. And I can release you from the amendment. I can release the seller from the amendment. So my job now is to make sure that we go back to the lender and say, now we're talking about $14,000 total at closing, not $10,000. Is that over the limit that is going to be advisable or allowed for this to close? Right?
Yes. Absolutely. That's very good, Dad. Exactly. Because if you're going to negotiate $4,000 additional closing costs, if the lender can't use it or if it exceeds the limits on how many credits the buyer can get, the buyer won't get it. It will go back to the seller. So then you can go back and say the lender says, nope, you can't do more than $12,000. It's just for argument's sake. So you have $4,000 or $2,000 more that you wanted to use, you can't use. I would go back now and do an amendment to lower the price by $2,000. There's your $2,000 there. And then ask for the $12,000, right? Combined concessions. So you can do it. It gives you the opportunity to go back and negotiate on behalf of your buyer properly by talking to your lender and seeing how much is available.
So this is one place that because obviously the buyer doesn't know all this. The buyer just feels, oh yeah, it's $4,000. It's going to come, in terms of the inspection. Yeah, I'd rather take that at settlement. So this is where we really, as agents, need to be knowledgeable to be able to tell the buyer, say, hey, look, this is the scenario. Let's go talk to the title company. Let's talk to the lender and make sure that they understand that this is the scenario we're looking at. Is this doable or not before we jump in there?
And a reminder too for all our buyers agents working with buyers. Oftentimes buyers see this as they're going to get a check for $10,000 at closing, and that is not the case. This is only offsetting fees and closing costs that the lender would charge them, and then so any abundance of that doesn't come to them. Cash to sales can be different, if you will, like cash out of closing. But if you're getting a loan, most of the loan programs and lenders restrict how much cash a buyer can get back. Like VA buyers that put down $1,000 down, put their zero down for the loan, they're putting like $1,000 earnest money, whatever it may be. The VA lender will allow that VA buyer to get that earnest money back only, nothing above that. So you check with your lender at all cases. So that's good. Last question. I'm going to Andres.
Sorry, I have one following question. So whenever you're in the option period and the buyer wants to, let's say, oh, this needs to be fixed and whatnot, so I want an extra $2,000. When he tries to negotiate that, can the seller terminate the contract, or he can just reject, and then the buyer is the only one that can terminate the contract during the option period?
Just the buyer. Yeah. Seller can't terminate based on a buyer wanting to amend the contract. But amendment has to be agreed by both parties. So if the seller doesn't agree to it, they rejected it. So buyer has their 5 days, 7 days, 10 days, whatever it is, to negotiate a basically repairs or concessions, whatever. And if the seller doesn't reply or doesn't agree to it, then the buyer's only option is to terminate under their option period, or to waive it and move forward without the changes they requested. Because there's still a contract. So amendment is we want to change our existing agreement, and both parties have to agree to amend the contract to change it. And so, the seller can't terminate based on the buyer's request. The seller can only terminate if the buyer doesn't deliver earnest money on time or the buyer doesn't close. Very limited. The buyer can terminate based on what you put in there, the option period, financing, property approval, subject to sale of another property, and so on and so on. So, yep. Very weighted towards the buyer. Okay. We've, hopefully that was helpful, people. It was fantastic seeing you all on the Friday after Christmas, by the way, too. And this is recorded. I know all your comments are recorded too, so you'll go down in history here at HomeSmart. But I will get this posted probably tonight or tomorrow. Make sure it's there in Real Smart Agent. Thank you all. Have a great weekend and Happy New Year.
Thank you and happy holidays to everybody.
Thank you.
Thank you and happy holidays. Bye-bye.
Thank you.
You're welcome.
Thank you.
Thank you.
Thank
Great
you.
meeting.
Thank you,
Thank
Mike.
you. Goodbye.
Bye-bye.
Thank you, Mike. Thank you all. Have a good one.
Bye.
Stop it.